Ladies and gentlemen of the jury, you have been shown a number of summary charts and other demonstrative exhibits. Please keep in mind that these charts and exhibits were used mainly as summaries of testimony and documents that were presented in this case. The charts and exhibits act as aids for you in examining what is going on in the courtroom. They are not, however, evidence in and of themselves. They are demonstrations, sometimes graphic in nature, of evidence. The weight that you give to it determines the value and the significance of the rest of the exhibits. To that extent, these exhibits do confirm to what you determine the underlying facts to be in this case, and you should accept them. To the extent that these exhibits may differ from what you determine the evidence to be, you may reject them. Ladies and gentlemen of the jury, you should not be concerned about whether or not the evidence is direct or circumstantial. Both types of evidence are proper and correct for your consideration. Neither type enjoys preference over the other in the eyes of the law. Direct evidence is the testimony of one who has actual knowledge of a fact. This includes eyewitnesses. Circumstantial evidence is proof of a chain of facts and circumstances that tend to prove or disprove a fact that may be in dispute. Circumstantial evidence is sometimes called indirect evidence, which means it is not direct in nature. Now, if you recall, ladies and gentlemen of the jury, at the beginning of the trial, I gave you an example of an eyewitness's statement that said the following: "It's snowing." It is direct evidence. Now, this is opposed to observing signs from which a conclusion could be drawn that it is snowing outside. That would be circumstantial evidence. In assessing circumstantial evidence, ladies and gentlemen of the jury, you should use your reason, common sense, and experience to infer from established facts the existence or non-existence of another fact. You should consider only the evidence, but you are permitted to draw reasonable inferences from testimony and exhibits as you believe are justified in light of your everyday experiences. In other words, you may make deductions and come to conclusions that reason and common sense lead you to learn from the facts that have been established by other facts. Now, ladies and gentlemen, an inference is a deduction or a conclusion that reasoning and common sense prompt someone with a reasonable mind to draw facts that have been proven by the evidence. You must remember that not all possible conclusions are fair inferences, and they should not become an inference unless you feel it is a legitimate inference. The law makes no particular distinction between the weight you give to either direct or circumstantial evidence, nor does it make a distinction between reasonable inferences that you may draw from direct or circumstantial evidence. You must consider all of the evidence that is presented to you, ladies and gentlemen, here in this courtroom. You must look at it and weigh it and evaluate it. You do not have to accept all of the evidence as true and accurate. You must decide whether you believe what each witness said. You must decide how important each witness's testimony is. In making that decision, you may believe or disbelieve any witness. You may believe all of a witness's testimony or part of it. You must not take into account the number of witnesses who are called to testify by one side or the other. In deciding whether or not to believe a witness's testimony, you must ask yourself several questions. Did the witness appear to be telling the truth? Did the witness have any personal interest in the outcome of the case or a case that is related to this one? Did the witness seem to have a good memory of the events relating to the case? Did the witness have the opportunity and ability to observe carefully and accurately the things about which he or she testified? Did the witness appear to understand the questions clearly? Was the witness able to answer the questions? Did the witness's testimony differ from other testimony presented here in the courtroom? Did the witness seem to be candid and forthright? Did you notice a difference in demeanor or storyline when the witness was taken on direct examination as opposed to cross-examination? Was the witness's testimony consistent? Did the witness's testimony contradict or conflict with another witness's testimony about the same facts? Did the witness appear to have personal knowledge about what he or she was talking about? These are just some of the kinds of common sense questions you should ask yourself in order to decide whether or not a witness was truthful while on the stand. You may ask questions during your deliberation process to clarify or update a situation if need be. Ladies and gentlemen of the jury, the weight that you give to each witness's testimony should not be affected by prejudice, bias, or some other motive. You should also ask yourself whether evidence was offered that tended to prove that a witness testified falsely concerning some important fact. You should also consider whether evidence was offered that was different from the testimony he or she gave before you during the trial. You may also consider a witness's inaction that is inconsistent with his or her courtroom testimony in order to determine the witness's credibility. Ladies and gentlemen, this is not an easy task, nor did counsel or myself say it would be an easy task. You should keep in mind that a simple mistake by a witness does not necessarily mean that the witness was not telling the truth. People naturally tend to forget. People make misstatements. Some people have lapses of memory or tell an unintentional falsehood. If you find that a witness has testified falsely as to any material fact, or if you find that a witness has been previously untruthful when testifying under oath, you may reject that witness's testimony in whole or in part, or you may accept only those parts that you believe are truthful or that are supported by other independent evidence in this case. Remember, ladies and gentlemen of the jury, you are the sole judges of the credibility of the witnesses. All right, this is